We will begin the meeting of the Hermosa Town Board. Work session, May 22nd, 2024, 6 p.m. Roll call, Ferguson. Here. Henriksen here. Hallsworth absent. Kramer absent. Kuntz.
Here.
Okay. Acknowledgement. Thank you guys all for coming. We appreciate the audience. Appreciate positive comments when we get that far. Call for changes. I would like to reiterate the meeting conduct. Raise your hand before speaking. Wait to be addressed. Be respectful. Limit your comments to 3 minutes. Refrain from negativity. Would be greatly appreciated. I need a motion for accepting the agenda.
I make a motion, we accept the current agenda.
Okay, second.
Second.
Any further discussion? Motion carried. Oh, I'm sorry, did you have something?
No,
Terry,
Okay.
did you have an addition on there?
I didn't.
The fee and that stuff?
I thought you were gonna do that.
Oh. I
Back
thought you
in the
wrote it
butt.
down.
So,
We want to add on the agenda, a couple things to add to the fee schedule, and also a discussion about billable locates.
So we need to amend that motion.
Yep. I amend the motion of accepting the motion. The
To
agenda.
include. Okay, do I have a second?
Second.
Any further discussion? Chuck?
I would like to add under changes, pace, so we can get an update on where they're at, what they're doing,
Add pace.
and gravel.
Okay. So we need to amend the amendment.
I'll propose an amendment to the motion on the floor.
Okay.
Can we do that in the middle of a motion? We can, right?
Okay.
To include Chuck's list.
Do I have a second?
I second it.
Further discussion? All those in favor?
I,
Aye.
Okay, to amend the original motion, do I have a vote, please?
Aye.
I,
Carried. And the original, we have carried. Okay. Conflict of interest declaration. There being none, we'll move on to abatements, complaints, and ordinance discussion.
Sorry. What did I miss?
Nothing so far. Well, there's a couple amendments, but that's about it. Before we start on abatements and complaints, I'm going to give a personal opinion as board president and also as the code enforcement, one of the code enforcement people. When this all started was last year. This is a follow-up on last year, what was started this year. Has not gone much further than what we were going to finish with last year. However, in my opinion, and it is my opinion, if we are going to do abatements, complaints, and have ordinances, we either follow them for each and every solitary soul here. We follow the ordinance as they are through that book. We don't pick and choose and say, I like you, so we're following that one there. Or, I don't like that ordinance, so we're not going to use it. In my opinion, if we are not going to follow it the way it is written, then take the book outside and burn it. There's been thousands and thousands and thousands of dollars spent getting that book written. So when I know I, for one, as the code enforcement go around, I don't look at anybody's names. I don't care. I write the violation per the address. I don't care whose name's on it. it doesn't matter to me. I have written myself up several times over the years for various things, and I have also fixed them so that they follow the ordinance. So there's my spew for the evening.
Afternoon.
Yes, ma'am. Yes, ma'am.
Oh, she had her hand up first.
Oh, I'm sorry, I didn't see it.
Well, and I agree with Vicky. If we have an ordinance book, it shouldn't pertain to the outsider and not the board members. We are all guilty, we are all residents of Hermosa, and I believe we all want our town to look good. I drove through where we used to live in Rapid City the other day, and I go, oh my God, I'm glad I don't live here anymore. Yes, we've had some things that we need to fix in our property too, and we're all guilty of it, but we're all guilty of not fixing them either. So I just honestly think the ordinance book
Jerry, I'll get
pertains
you in just a
to
second.
everybody.
Thank you. Jerry?
What I'd like to do is just read the oath that every board member has taken. Having been hired to the office of the Board of Trustees within and for the town of Hermosa in said county and state, do solemnly swear that I will support the Constitution of the United States, the Constitution of the state of South Dakota, and the ordinance of said town of Hermosa, and that I will fairly and impartially, to the best of my knowledge and ability, perform all duties of my said office. And this is pretty much what Vicky just got done saying.
Thank you. Okay. I'm sorry. Yes, your turn.
May I shut the blinds? I had
Oh, yeah.
my eyes dilated.
Oh, I was wondering why you had shades on. I thought
forgot
maybe you were
that
trying to
had
be
that
a
done, yeah.
cool.
No, I'm not trying to be cool.
You want these?
Kids in high school used to wear shades in class, but it doesn't
Yeah.
count.
Or I thought maybe she had a black eye. You want these shut over here too?
This one, she's getting it there, Jill's getting it, and that one's good enough. Thank you very much.
Better?
Yes.
Okay.
Much.
So in addressing the schedule here that Jill was so kind, spreadsheet that Jill printed up of the letters that were sent out immediately, 6 of them were taken care of.
Is that on here?
Yeah. No,
No.
I can tell you the one.
So please do tell
470
me.
Manning is done.
Thank you.
Second North Fifth Street is done. 10 North Fifth Street is done.
Potholes are being repaired and bars.
255 Ferguson is done. And 220 Folsom is done. No screaming, no yelling. They just went along with it. When the letters were sent of complaint, the ordinances for the most part were sent. Some of the letters that were sent were asking for information to validate events that have taken place since, or check safety on various buildings, etc., etc. We were on item number 1, which was to mail the letters. An example, when the letter went out, without the name, it looks like this. It was filled out, and then the ordinance accompanied it with a short letter that said, please bring your violation into compliance with the ordinance, and the ordinance number was listed, and it was signed. It will be rechecked within 6 to 10 days. Everybody got the same thing. That is what the policy showed was the first letter. Haven't gone any further because of all of this. Yes, ma'am.
So on this particular sheet, it says either a call, a door hanger, or a letter. And
On
so
which
it's
particular sheet?
right here.
Okay, but on the ordinance in and of itself, item number 1 says send a letter. That's what we did. Last year when we did this, Donna decided we should do a courtesy call. I myself went with what the ordinance read because it gets so time consuming. You do the courtesy call, that's 3-4 days. Then you do the letter, that's another 3-4 days. So I went with the letter because then you have it in paper, you have the date it was mailed.
Yeah. And to that point, a call, and a courtesy call, that's great, that's neighborly, that's the thing to do. Do it if you want. But don't let your process be slowed by that. Don't let your reliance on the resident to be dependent on that call, or whether that call even happened or not, in their opinion. So they can always say, I don't remember a call, maybe it was my kid you talked, whatever, okay? But in order to complete legal service, you can post, which means posting it on the door of the actual violation. Whether that's a door hanger, I don't know what the door hanger says, but it should have everything you put in that letter. So, and then on something like this, first class mail, certified mail certainly, for service of process, all constitute completion of service.
Certified is like in step 3.
Sure, so, but each step of the way.
Right.
You want to overkill. You want to make sure that you get yourself covered.
Yep.
So, and it may upset people, and nobody likes to get a letter saying their place isn't Better Homes and Gardens. I get that. Literally yesterday or today, City of Rapid City replaced 2 big long lengths of concrete sidewalk in front of my one of my rentals. I'm sure it was going to cost me a lot of money, but it just is what it is. I wasn't up there protesting it because I knew the sidewalk was beat to hell, you know. So,
Yeah.
and since 1910, it was probably ready for it.
Yeah.
So it is best, again, to the extent that being a good neighbor, even as a governmental entity, being a good neighbor is important. Got it. Totally agree with it. I just think that in addition to that, you're always observing the steps of the process so nothing gets slowed, so nothing is mistaken, or something else can't be misrepresented by either side.
What we did, because I just got on the board last. What we did last year, I think the reason why we made phone calls was we worked on the grass. We worked on getting the yards mowed up before the fair. And it was very beneficial as far as doing a phone call or stopping by afterwards. Cal was out working in his yard with his
Yes.
kids, and I said, hey, your yard's really, not that he'd gotten a phone call or nothing, but he had his kids out there helping him dig out, and that's kind of where we started, and then it kind of just ended. Now we're into the more depth of cleaning the town up.
And then to that point, I think, again, that's another benefit to all parties, but especially the town, is that a phone call, if they go out and take care of the issue, if it's just grass or trimming a hedge, beautiful.
Yeah.
Quick, easy, cheap, done.
Okay, none of the ones that were written at this point of this year pertain to grass. None of them.
Okay.
And usually when we go address grass, we wait till after the weekend so that everybody's had a chance. And of course, if it has rained,
Yeah.
we allow extra time before we go look because that's only fair.
Sure.
And we allow it for everybody, not just one, not just two. We don't pick and choose.
And we
I
had
kind
some
of put
good
my sunglasses
results.
on and drive around and say, write this down.
Mhm.
I try very hard to be fair. Joan?
Well, we do have ordinances, and I agree, we either need to enforce them or change them. I mean, they are there, I don't think we wanna burden them, but, you know, we have the option to change something if we don't think it is fair and necessary. However, just for professionalism and consistency, I think that we should be using a form letter that you send to everyone, the same form letter, not a handwritten letter. It's
I was
just-
trying
it's
to
just-
save office
I
help.
know, but it is just more professional in my opinion.
Yeah.
That's just my opinion. Also, and I didn't realize you didn't send any for grass, but I
Nope.
think the beginning of April is a bit early. You haven't given the people a chance to do anything on their own yet. I think when June rolls around, you can pretty well tell who's not gonna be taking care of the yards and who's not gonna be out there working on things, and it just seemed a little bit early to me is all.
No, this is
And I think
May,
maybe, I mean,
and we already,
when the first notices
But
went
we
out,
already
it was
had
early April.
almost 30 violations.
No, aside
Well-
from that, I'm just saying maybe we could have, you know, a standardized time when those letters go out. We
Well-
need to give our citizens the chance to work on their own time schedule also and feel like they're accomplishing their needs or whatever they want to do in their yard, not just, oh gee, we had a nice day, it's April 1, let's pounce on everybody. I think that just caused a little bit of hard feelings is all.
Well,
And it's just an opinion.
we started last year fairly early also. Jerry?
I just want to say, I got a letter, I thought it was very professional, it was handwritten, it was very clear, the ordinance was attached to it, I knew what it needed to be, I read the ordinance, and first thing I thought to myself was, you know, these lilacs have been here since forever, and they've been out of compliance forever,
Yeah.
but that is irregardless. I was out of compliance, so I had to comply.
Thank
And
you.
it said you're gonna come back and look in a certain number of days, and it's just that simple, you just gotta comply.
Don?
That's what Trina thought. Okay, and well, it's kind of referring to what Joan was saying, but we did have cleanup day in April.
We did.
And with letters going out, that was a chance for people to do some extra cleanup of the junk and stuff around their yards. So I don't think there's any certain time. You know, if you got a mess out there, so what if it's April? Can't you clean it up before June? Why let it lay
I
there
allowed
another?
it to happen.
I
Joan?
think- I think it does, you know, maybe there can be no certain time, it probably does depend a lot on the weather, whether it's been raining for 3 weeks or it's, you know, been good weather. And the only other thing that I wanted to mention was the fact that a lot of trees and hedges and shrubbery was mentioned. And for people that can't do that themselves, it does take a while to get on some yard,
And all it requires is a phone call
yeah.
to say, hey, I'm still looking for somebody to do it.
you know, to get under
Originally,
the
this says
stir
7 days, and I put in there 6 to 10 days. And all that has to be done is contact Jill, myself, Donna, Terry, and say, I can't find anybody.
Well,
Give me a little extra
I'm
time.
not gonna say I can't find anybody, I'm gonna say I haven't found them yet.
Okay? Justifiable? Jerry?
And there's also within Hermosa Connects, there's a fund down there for, you know, seniors and people who can't afford to do their abatements. There's a fund there that citizens have donated money to that will pay someone to go and do whatever the abatement might be, if they can't afford to pay it.
Or if they don't know somebody to do it.
So, Mr. Haig, light up my life with suggestions what we do next.
Well, regardless of the form with which the letter is sent, I think, Joan, it's a good idea to have it very standardized. The less,
Well, we've had
Personal.
them in the past.
yeah, the less personalized it can be, the better in a, especially in a town of this size.
Okay?
Everybody knows everybody.
I know.
And everybody that kind of likes or doesn't kind of like everybody, right? Fair enough, let's just say it.
I wrote them, I signed them, it
Yeah.
kept it out of Jill's
And-
hands, she had to take the time to address the envelopes. All I was after was saving office help.
Absolutely, and also probably thinking that the personal touch would,
Yeah,
the
kinda,
buck,
you know,
kind of
that
the
might
buck
help.
stops here type thing.
Yeah.
And if you don't like it, please let me know.
Call.
So regardless of all the good intentions, because I think it can be construed as the neighborly thing to do, can also be construed as, oh God, she's writing me a personal letter, she's picking on me, she's doing this, she's doing that. That's what I'm hearing. And nothing is, I think if everybody knows and is 100% certain that everybody is getting equal application of the law, and these ordinances are being applied to everyone who's out of compliance, within reason. If you got a couple branches of a lilac hanging over that's not supposed to be, and you're picking on that person, that's where it gets into the ridiculousness of, okay, you're picking on me, and that's true, you're doing that. But when it comes to fundamental things, the junk that's in violation of ordinance. The most importantly, life safety issues like the violation of encroachment of the site triangles, things like that. It's all to a large degree, common sense. And when that common sense is misconstrued or isn't there, then it results in people getting upset, justifiably so. If you think you're not getting treated fairly, of course you should. That would upset you. It would upset anybody. And you need to be heard. Everybody needs to be heard. And just again, application equally. Everybody knows everybody to some degree in this town. And if the Joneses down the street got a letter, I never could stand those butt heads anyhow, but they got a letter too, just like I did, so I'm okay with it, type of thing. So again, I would go with the form letter to give it that less personal touch.
Okay. I can do that, saves me getting writer's cramp.
Roger that.
Okay. Mr. Stiles.
Kent, with that said, these are still valid write-ups.
Doesn't mean they're invalid, no. I'm saying the political effects of that, it doesn't invalidate what was provided. You're exactly right. That's true, and I didn't want to infer that. I'm glad you made that clarification.
Okay. So, are we lifting the moratorium on writing these? Are we continuing? Are we letting go of this? What are we doing? Because I know 2 yards right now that are about 18 inches tall.
The 1 yard I did stop and knock on his door Saturday, but after I was over at the dumpster. But he didn't answer his door, so.
I think the answer is a resounding no. Don't not proceed. Proceed, in other words.
Okay, go ahead and proceed.
Double negative.
Cal?
But, yeah.
You done?
Yes.
I don't want to step on you.
Go ahead. I have loafers on, you got steel boots, maybe that'd be
Yeah,
verified.
that'd be a good idea. So, you know, being as I'm new to this and everything, I'm not really sure what's going on and everything. I ended up getting a copy of all the complaint forms, and I went and walked the neighborhoods and stuff today before the meeting and just checked it out. And my main focus was the site triangles, because I know that's a big issue, but I do also know that driving around town, I never seemed to think that, you know, I had any visibility issues on the corners that I was traversing and stuff. So I ended up looking at the ordinance here, and then I took and the ordinance provides a measurement here from the corner
Right.
along the property lines. And so, I mean, I gotta tell you, a lot of these corner impediments I did not see when I got out there and I measured along there. So, and I can kind of tell you how I did it and see if that's valid or what, but I mean, some of them were pretty far off, you know, because now I went from the line, basically the grass line, where the grass and the dirt meet. Is that considered to be the property line here, or is that not?
I don't know where the property line is, that's why I left it up to the property owner and just said, you know, please bring your property into compliance, because I did not want to trespass.
To that point, I think the rules of the road would apply. And that your stop spot, your, what would otherwise be a pedestrian crossing or whatever, but that place that you're supposed to stop by law, and then you look either way, I can't remember the exact angle, I want to say, let's say it's 45 degrees, either way, you're supposed to be clear. There's your measurement, regardless of where the property line is, regardless of all of that.
Okay, the other was frontage. It also lists frontage. Can't be more than 5 feet in front of your house, just like a fence. So there is that issue also. So accordingly to what I read and what my belief was if you've got property that has the triangle, go out and measure it and bring it into compliance. Because I'm not going to go measure it, nor is Donna, and be on your property trespassing. Mr. Stiles?
Yes, the ordinance, if you go back in, it's not in this section here that you, excuse me, ma'am, when I go to talk, I don't need you making noises.
I'm breathing, sorry.
It's very clear in the other ordinances, it's from the corner pin. And that's one of the things that when you go to do put a house on a lot, that's one of the things that's in the review deal. It's from the corner pin, 20 feet back, corner pin, 20 feet back. It's not from where the grass on the road is. The ordinance is very clear on where that is. It's 20 feet back. And you talk about you never had an incident. A guy almost ran head on into me the other day. I was coming on my side of the road around this greenhouse up here, and that guy, for some reason, cut the corner short. I had my trailer behind me, maybe I was going 5 miles an hour. If I would have been going the speed limit, it would have been head on. So it's not from out in the street. The ordinance specifically says from the pin, and then when you build a new house, that's the same thing, you can't have any structure in it. Now, there's some houses that were built a long time ago,
Yeah.
That's not an issue. But as far as the health and the safety and the welfare of the citizens, all properties within the jurisdictional boundaries of the town will comply with all provisions of this chapter without regard to conditions existing at the time that this goes into effect. So it's from the corner pin.
Well, in other words, it's not, nobody's grandfathered in when it comes to side triangles. let's say.
Yep. And it's
Or
goes from-
nuisances, by the way.
Or it comes from it goes from the pin, exactly what the ordinance says.
You know, and
It's not from where the gravel meets the grass.
I'd have to refamiliarize myself with that, but when it comes to side triangle and pins, there can be a difference, not always. There can be a difference, because if your pin is way up here, which it shouldn't be, because you're in right of way, it makes sense that the pin would be the spot, 20 feet back. That probably makes total sense in most of it. But again, as you're a driver and you're stopping at the proper spot per rules of the road, statute and ordinance, and you got this going away, if your pin is here, but you're 45 degrees here, or your pin is here, your 45 degrees here, that would be a secondary aspect to looking at what's impinging on the rule, on the view.
Kel?
But we're not
Wait,
talking about
Jerry, just 1 second. Kel?
So, the definition I was going by, I pulled from the ordinance on 155.58A1. And it is, here, check this out with me. So, shall be provided, so there shall be provided an unobstructed view across the triangle formed by joining points measured 20 feet along the property line from the intersection of two streets. So it doesn't say the pin, it's the street intersection. And so that's why it was kind of like, well, because I didn't really know where the property line was, but the street intersection is basically kind of, if you go
Donna, I'll get to you in a minute.
along the edges of each street, right? And then that's where the point where those two streets meet.
Yeah.
Should be the street intersection, right?
And it goes on to say, within said triangle, there should be no site obscuring or partly obscuring walls, fence, or foliage higher than 30 inches above the grade,
Right.
or in the case of trees, foliage lower than 8 feet, etc. So even though it does talk about property lines, which can refer to pins,
Where the pin is.
right? But that's not overriding if that pin is, just so happens to be in a spot that if something is there, it's okay that it obstructs your view. The primary reason for this whole ordinance, again, going back to health, safety, and welfare, that's your common sense aspect of, by God, my pin's here, so I'm not gonna do, well, no. By God, the site triangle's like this, and if you're obscuring it, fix it.
Deb?
I was just wondering, did you stop at the stop sign there? There is no stop sign.
There's no
So
stop sign.
you've got traffic going.
Okay. Jerry?
Yeah, and one of the things, you know, when you're looking at why it says from the pin, and it's very specifically in there, that you go 20 feet on your property. Well, your property's not out in the highway. Your property is from your pin back, both directions. So it's not out there. It does refer to a height that you can use as a height outside your property, and that is if there's not a sidewalk, the 32 inches is measured above the street level, at the street level.
Donna?
There's not a sidewalk. So,
Well, my feelings in this whole deal is, if you got a letter, why don't you just take care of it? Why do we have to have such a big discussion about it? Go out and look at your property. Does it look a little shuggy? Shrubbery need to be a little trimmed and stuff at the corners so that people can see, can have safety? What's the big deal? Half hour of your time, maybe.
Lon?
So Donna, my corner is one of them being referred to. I don't have a problem with the sight distance on my corner, so don't think I need to take care of it.
See, and that's the
Seeing that, I
problem.
disagree with you on that.
That's the
And
problem.
the other thing is, you do not trim lilacs until after they bloom. They're just thinking about blooming now.
So then just
And I
refer to
probably
that.
will take care of them after they bloom.
Jerry?
yes, I want to add on to a little bit what Donna said. You know, when I first got the thing, I thought, oh, am I being picked on? I asked Jill. Jill says there's 30 of them out there. I says, fine, okay, I'll take care of mine.
Thank you.
And I took care of it right away. It would have been a lot easier for me to wait until I actually demoed the property and did it then with an excavator instead of with a chainsaw that took probably 12 hours of my time.
Okay. Linda?
But we need to comply, and it's very clear when it says 20 feet along your property line. It's clear then, where's your property line at? Where the pin starts, so it can only be 20 feet from that pin. Your property don't start out there next to the street. That's
Linda?
the way it is written, and that's the way it needs to be complied
Okay,
with.
Linda?
Now, is it unfair to some, because what you're talking about, it's unfair to that greenhouse over there, because the road on that corner sucks real close to them right there, so they don't get that extra space like I got on the other side of my street. So then, you know, you look at their property line, and if you don't go from property line to property line, well, then it's not fair to them because their street comes right up to their, right, the corner, right at the valve, right at the property pin.
Linda?
So that's why you have to go with the property pin and not how the streets work.
Linda?
Thank you. I have measured my corner, and I'm way within my rights on my corner. On between, however you want to look at it, my property line, my property pin, my lilacs to the stop sign, any corner on my street, you can see at least halfway up the street. My lilacs, my trees do not impede anything. And That's number one. Number two is, as I recall, and I'm not saying that this is the way it is now, or that it is the way it should be, or any of that, but what I'm saying is that the ordinance in the past, the subdivision ordinance was for new areas. It was not for the old town. The old town has its own look, its own thing, and it's some of yes and some of no, but we are still trying, I think, it was my opinion, or it is my opinion, that we are still trying to be a small hometown community. Ranch community, yes, we're trying to improve, agreed.
Just a minute, Donna.
Agreed. But that ordinance was first designed for new subdivisions coming in. It had absolutely nothing to do with the old town. The reasoning for that is because the roads were 80 foot wide for the old town. The reason being for that was because back in the day when they were built for horse trains, long, 6 horses and a big old trailer behind it. And so for them to make the corner, they had to have the 80 foot. None of the new streets in town are that way. They're 40 or 50 or maybe 60. So you have to be more careful when your streets are narrower and shorter. Now I agree that the ordinance now does say that. That is because we were getting, and I don't know what year this was, I don't remember, Joan, maybe you can help me. Maybe you can help me, you were here too. But with all the new ordinances that we were coming up with, our ordinance book was a horrible mess, and things were duplicated and triplicated and quadrupled. And so we decided to spend the money and send everything to a company that went through it all. And they were supposed to have taken everything and condensed it so that nothing was there twice. It was all very nice and simple. Well, as it turns out, I don't think it is very nice and simple. I think it was not put together correctly. However, you want to step in, Joan? Go ahead.
No, I was just gonna say.
Excuse me?
When we
sorry.
did have that done.
It was my turn, so-
Immediately when the book came back, because of whatever permits were on at the time, we found several mistakes, which we rewrote and had them fixed right away, but no one, I don't believe, ever went through the whole book, so there were duplications that weren't caught.
Okay.
That's-
My take too is nowhere in here does it say, unless you live in this area, it's grandfathered in. It applies to everyone. It does not say, well, this subdivision has this set of rules, and this subdivision has this set of rules because of the date it was established.
That's right, and it goes to nuisance law.
Right.
Okay, there is no grandfathering in law, in common law or statutory law. Nuisances are not subject to grandfathering.
Okay. Donna?
Well, that's what I was gonna say. I mean, do we have one set of rules for the old part of town and one set of rules for the new part of town?
And where are they?
Yeah, where are they?
Jerry?
It is very clear on how to make a determination on the corner. And you don't have to go on people's personal property to
Right.
do it. What you can do is a right-of-way, anybody can be on the right-of-way. All they need to know is where that pin is, and they measure back 20 feet. And some of the older places have wider streets. They have a wider deal, but still the ordinance says 20 feet along your property. Your property don't go out in the street, it starts at your pin. So that's how you can verify.
So in other words, we need to ask the property owners to locate their property pin so that we can come out and measure it. I think it's much simpler to just say, find your property pin and fix it. Joan?
I think there are several older places in town that don't have pins.
Oh, I
I
disagree with that.
disagree.
No, I know that for a
Mark?
fact.
I just, I think maybe a couple ordinances are maybe getting confused slightly here. A sightline ordinance and a 20-foot setback ordinance are two separate issues. When you're measuring a sightline, you look at what's considered a fog line on the road, better,
Yeah.
is the center of each directional lane. And you basically, if there's a stop sign, you measure 15 feet back from that fog line. And then if there's a stop sign, it's like a 60-degree angle. If there's not, the angle changes. I'd have to relook it up exactly. It's been a few years. But there are very specific. And it's also from the top height of the road. So if your property sits down 15 feet, do you understand what I'm saying? That, well, obviously, our ordinance reads what, 32 inches?
I don't have the ordinance.
I guess I don't have it in
It's
front of me.
32 inches, yes, sir.
So 32 inches, that would actually be from the top crest of the road at that fog line, straight across to the top crest of the road, kitty corner. I just think maybe there has to be some very good clarification on exactly what is in violation and what isn't before we tackle something, which brings up the other thing, street signs and stop signs. If you have a 3-foot stop sign,
We're working on that,
It
which I
changes-
indicated last night.
it changes, you know, your whole sightline picture and your triangle for safety.
Mr. Haig, my question,
Oh, go ahead.
please. So, with what is written for the violation issue here, 155.58, do we change this? How do we interpret it? Is it interpreted to go from the property line, the sight line? What are we using here? Because this is where the problem is. People are seeing one way, I'm seeing it another way, somebody else is reading it another way. So how do we come to an agreement on what we are applying?
Right. It depends on the goal, the criteria that you're trying to effectuate to a uniform level. That is primarily the site triangle. And to Jerry's point, from the property rights standpoint, here's my pin, here's what I gotta do. I get that. However, if your row of lilac bushes goes beyond your pin and into the right-of-way, which is considered the public right-of-way, dedicated right-of-way, you still have an obligation to clear that as well. Your property responsibility or your responsibility for obstructions does not end at your pin.
And I'm not saying that what it is.
True.
What I'm saying is
that's-
that's where you measure.
Jerry,
And-
Jerry,
So what I think it comes down to, again, going back to common sense on the matter, it's easy to fall into, well, it's not here, it's there type thing. Okay, very simply then, and exactly what you said, 15 feet back from the stop sign, if that's the rules of the road that are very clear. This isn't just Hermosa, it's a state statute. You know, so that's what should prevail. Now, if it's something where it's a nuisance abatement, and what does the town have the right to do on someone else's property? Well, if it's declared a nuisance, it can go on to someone's property, abate the nuisance, and charge them for the abatement. Boom. So, yes, I'm started from when I was an assistant city attorney in Rapid City in the early 90s. 1990 to be exact. Yeah, quit laughing. It's very important, again, the even application of the ordinance. Everybody needs to be treated fairly. But what does the law allow? And that should be, in my opinion, to any reasonable common sense extent, take common sense back a little bit, because the law is the law. Although there's always gray area, I get it, But if it means property pins or whatever else, if it's in the ordinance and truly under the ordinance, private property can be entered upon and abated, that needs to be effectuated. So, I'm probably not articulating this very clearly, but when it comes down to site triangles, it is common sense.
Jerry,
Okay, and
last time.
And okay, I understand it's common sense, but on the site triangle, we need to change the ordinance then. Because the ordinance is clear, it's 20 feet back on your property. That is how the site triangle is defined. That's how the engineers forever have looked at it on stuff, that's what it is. So, if you want to say, and it's fine, 10, 15 feet back from the stop sign, then change the ordinance. But that's not what the ordinance says right now. And nobody up there at that board, including you, Kent, has the right to say, we don't have to comply with that ordinance.
No, you're wrong, I do. I'm just kidding.
No, there's an exception here, let me read it. The Board of Trustees shall act and perform all the duties and exercises the power of the Board of Adjustments. The Board of Adjustments shall have the power to make special exceptions to provisions of this chapter, provided that the applicant for the special exception shall first file with the Board of Adjustment a consent signed by not less than 75% of the owner's property within 500 feet of a lot or site of which the special exemption is sought.
And that's a completely different application than and it's 30 inches above grade, and the crest of the road is considered the grade.
Right.
Again, going back to what is going to effectuate a safe entry into the next street, into the cross street. So the language that you just articulated, Jerry, although true and is an overriding aspect, in the law, the specific always takes precedent over the general. Of course, they must be constitutional. It goes back to equal application of the ordinances. And those other items, not every criteria applies to particular ordinances the same. Again, so that's why we have ordinances that deal with specific things. And when you have very clear language here, with regard to said triangle, there shall be no site obscuring or partly obscuring walls, fences, foliage higher than 30 inches above grade, or in the case of trees, blah, blah. Okay, so that's really what it comes down to. And did you talk to the Joneses, the Smiths, and the Carlsons equally if they all had violations? Then that's your equal application of the constitutional protection of the law. But by God, they all got to observe what's obscuring triangle.
Okay, there's also the issue of if it's frontage.
The frontage thing, I'm not, yeah, that's not even in the triangle.
No, I'm just saying,
Yeah.
as a separate entity, there's the issue of frontage also, and it states 5 feet. Fencing, shrubbery, whatever. So, how do we apply that?
If you think that 6-foot lilac bushes, which most of them are 8 to 10, are acceptable, although you can't see the lovely house behind them, I would say change that ordinance. 'Cause I don't.
But until the ordinance is changed,
Yes.
should it not be adhered to?
Where is the law looks at the rationale? If the ordinance says your fence cannot be more than 5 feet, okay, that can be handled when you apply for the permit to erect your fence, or should have been. But your lilacs, which have been there since 1930, are growing high. To insist that those become only 5 feet high, I don't see. So that's an example of where we
That's where
should
I'm
change
at.
the ordinance.
Okay, but until the ordinance is in effect, what do we do? If you're gonna change the ordinance, until that is changed, should it not be adhered to?
I don't.
Donna?
Personally, I don't think so.
Donna?
Well, it just brings back the same old thing. evidently what's good for one isn't good for another, so I don't feel that we've got any place on this lilac bush issue,
Well, it's sightline, it's frontage, it's
you know.
lilacs, it's shrubbery, it's fencing, it's,
And it, you know, it was wrote up in the ordinances. Who did the ordinances? Did they not check the ordinance after they were printed up from this so-called company or whatever? And say, hey, this is not the way we want it. And does the ordinance pertain to the old part of town and not the new houses that come in? I mean,
Mr. Stiles, last time.
I guess what mine wasn't in the side triangle.
No, yours
Mine
was frontage.
The frontage. I measured and I wasn't in the side triangle. The ordinance says I had to be under 5 feet. I wasn't. I complied with it. I think because the reason I complied with it, and I'll tell you why I complied with it. I was in a meeting one time and it's on a recording, and I can bring it and I'll let you listen to it, Ken. It was actually when one board member wasn't complying with something, and the lawyer yells at me, calls me a name, and says, answer my question, and yelling. And he says, what do you want me to do? And I says, well, I think you need to enforce the ordinance and comply, and make that individual comply. And the answer was, do you think I'm gonna prosecute him? No way. And I says, okay, fine. What if I do the same thing? You know what came out of his mouth? It's on a recording. It says, I will prosecute you. Now you talk about equal and
I
fair.
presume that lawyer wasn't me.
No.
No.
Oh, yeah.
Galbraith?
This is declared.
Galbraith?
I mean, I think that, you know, pretty much everybody's comments are valid, or everybody's are, you know. And I'm not here trying to argue against safety or anything like that, but, alls I'm doing is I'm pointing back to the ordinance, because what the ordinance will provide is an objective measure by which somebody can, if somebody doesn't agree with the form or the complaint or anything, then we can both read the ordinance and go, okay, well, am I in compliance or not based on what the ordinance says? And so that's why I went out and I just wanted to see, because, you know, from driving around, I didn't see anything in particular that was blocking my view on the site triangles, but, so, I just want to ask Kent. So it goes, the site triangles formed by joining the points measured 20 feet along the property line. So this is, I don't know if Mark was making a comment, but this is not a setback. This is supposed to be defining the site triangle, which is when you're doing 2 streets, that site triangle is supposed to be 20 foot from, it says from the intersection of the 2 streets and then along the property line. And Jerry made a good point too, that the property line doesn't start at the street. So
No.
how should we interpret that from the intersection of 2 streets, do you think?
I'm gonna tell you, hold that thought and declare an intermission, because I gotta, before I have an old man moment.
All right.
he's gonna do what? Leave out through the window in there?
I got one that shouldn't need Kent. The other one that I got an abatement on is a large branch of a cedar hanging out in the right of way with a post holding it up. So, I mean, cedar trees, if you cut the lower limbs, the next one just wants to fall. So they'll keep falling always. That particular post that's holding that up is got a strap going over the top of it. The post cannot fall down. It might fall over. The branches are gonna fall all the way to the ground. I just have that there so I can park my car under there so I don't get hailed on.
Is it in the right of way?
No.
Okay.
And I mean, if I have to comply to that, okay, but like I said, another branch is gonna fall. And probably, it may take it a couple of years, but they just keep coming down.
Well, we just need to know where the property pin is so that we know if it's on your property or in the right of way. Yes, ma'am.
It depends on how you want to declare that. My property line, our property line, is basically the fence, all the way around.
Okay, so it's in the right of way.
However, I have used that driveway for 35 years.
Still the right
I
of way.
have maintained it.
We all maintain our own right of way.
Yes, we do. I have maintained it. I gravel it. I mow it. I weed it. I park there. I've parked there since the beginning of my time. The people that own the house before me parked there before their time. And it's
still the right of way.
a right of way that bothers nobody.
It's still the right of way.
Well, it's not a safety issue that a post cannot fall.
Right.
If you're walking under it, it can be a safety issue.
No, because I can walk under it, and there isn't very many people that are taller than I.
But that's an exception, Lon. You've got a tree branch that's starting to fall.
The tree branch is not gonna fall, it's gonna
It's
settle
in the right
over
of
to
way.
the ground.
Okay,
It
wait a
doesn't
minute,
have an
wait.
exception there that says unless the branch is blocked up. It's a right of way.
I actually think we need an impartial person that does abatements.
Well, good luck with
Because
that.
there is too much conflict with
No,
people
that's
on
not
this
why
board.
I'm being conflicting about it. I'm trying to be fair. Can anybody else have that happen in a right of way? Probably not.
Probably can.
Depends
So-
on their right of way. Depends on what use their right of way has. Mine does not have a sidewalk. Mine does not have a walking path.
But does it say in the ordinance the right of way constitutes this unless this?
No, but I can ask for a variance.
Well, then do it.
I missed
Do
the
it.
first part of the fact pattern.
We thought you weren't needed on this one because it was
Well, how'd
just,
that work out for you?
real good.
Yeah,
Yeah,
I'm sorry, I'm getting way too cocky.
it's all right. We're talking about my property, and Lon's question was, one of the abatements here is about a tree limb and being held up by a post. And it is in my driveway. My driveway, depending on how you want to look at it, is it within the right of way or is it mine? It's mine. I look at it like it's mine. I have had that driveway ever since I bought this house in '88. It's been my driveway. It's never been public use for anything. The tree itself, the branch, cedar tree limbs fall. It's just the nature of the game. And if you cut one on the bottom, then the next one's going to go to the bottom and it's just going to keep dropping. Well, anyway, it's where we park, and so Lon put a post underneath it. The post is attached to the tree so that it won't fall over and hit you in the head or smash your foot or any of those things. It is just in reality so that you can walk underneath it, to get to your car, or park the cars underneath there for some hail protection, because we have it. That tree, that limb has been out there since I own the house. The lilacs were all there. The limbs were there. I know this is neither here nor there, but it's the truth. And I believe that, my belief is that ordinance was written for new buildings. It was rewritten wrong, agreed. It does say that now, agreed. But sometimes you have to, in my opinion, you need to use a little bit of common sense. The old town is the old town. You're not gonna get away from it. We've been trying very hard to maintain a country feel, you know, ranching community, country feel, you know. And in my opinion, we do not live in a gated community. You know, if you want to live in a gated community, pay the dollars and go. This is a small town. Yeah, do I want it to be kind of neat and kind of clean? Yeah, kind of neat and kind of clean. But I'm not as picky as most people are, and I know that, and I'm okay with that, and I hope everybody's okay with freedom. Let's say that. It all has to do partially with freedom too. I'm not telling you to paint your house red. I'm not telling you that you can't plant a lilac bush. Those are for gated communities, in my opinion.
Donna?
I'm gonna say one thing on this, and then we're gonna close this abatement because we are not
Because I have a
getting
comment,
any
thank
place.
you.
I feel what Linda is saying, that the ordinance is road for the new part of town, that the people in the old part of town don't have to follow them. And as far as your branch, get a variance for it and you're clear. It's that simple. Now let's move on to something
Well,
else.
I have a comment. Nowhere in this abatement book does it say, unless you were established here, unless you were established there, unless you live in this development or this development. It is a generalized ordinance, and that's what I went with. It does not say, you know, oh, well, you parked on there for 35 years. It is still a right-of-way. It is still your obligation to maintain it. I have to maintain mine. Kel has to maintain his. Everybody in the audience that lives in town has to maintain their right-of-way. Okay, so are you going to tell me then, Kel moved in, so his rules are different in his right-of-way than mine are, and then they are different because Jerry moved in and we changed those because he's a newbie in town? Or are we going to take what is written in this ordinance, follow it for now, and amend it? But in the meantime, you still need to follow it. It was written by a couple members on this board, and I know years ago, and yes, I'm going back, Linda, but you have too. Years ago, the nuisance ordinance, it was put to a guy, oh, sign it, that'll never come into play anyway. But it did, and it's still in play now. My issue is, it is not stated that we have an exception here and an exception here and an exception here. It's all written very general. So how is it to be interpreted as, well, you moved in 1935, so it doesn't apply to you?
There's a number of different legal issues that can be dissected into. Pre-existing use, so therefore, when zoning or right-of-way changed, going back to the 1935 example, let's say the right-of-way changed, but it was a pre-existing use, it's called a legal non-conforming use.
Okay?
Okay, so there's that aspect, a whole genre of things. The tree, God knows how long it's been there, since you bought the place.
Well before
And
that.
I'm not familiar with, I'm just very generically applying what I did. The primary reason for right-of-way is so that a municipality has the ability to work on its streets, expand its streets, and do whatever it needs to do within a set dedicated
Right.
piece of area. That's number one. The second one, okay, does something exist in the right-of-way that's a life safety issue? Because that's the reason you would have, okay, if that old cottonwood is, it's a great shade tree, but man, that thing's starting to teeter and looks like the next halfway decent wind's gonna plop it over on somebody. There's a life safety issue. If it's Canadian thistle growing up inside your piece of right-of-way, there's a nuisance life safety issue, and the city would have the ability to go in and spray it or whatever, but again, people are expected to maintain their piece of right of way. So where does this scenario come in? Is it life safety? So it's the test that the courts would apply is a rational basis test. Is there a rational basis between enforcement of the law, existence of the law in fact, and the desired outcome of the health, safety, and welfare of the community? That's always the balance. And the rational basis test must be implemented in the least restrictive means possible. Okay, so what's that mean? Well, does it mean that you call it the National Guard to get her
No, I'm gonna call you, take you with me.
I got a little electric pulse saws on it. I could probably help, you know. But, so I could ramble on about what's in the textbooks quite for a while, but I won't. However, I agree with you, Vicki, when you say if something is inconsistent with the standards of our community or the desired standards of our community based on a general perception or what the majority want, then let's amend the ordinances accordingly. Let's read through, let's highlight and say, okay, we agree that if you apply for a permit for erect a fence in front of your house, on your property or wherever, but it'd have to be in your property. If it's over 5 feet, you gotta get a variance. Now, if you have lilacs that have been there forever, or not, but they grow more than 5 feet, and it's not a life safety issue, that's a different deal.
But what about the ordinance reading? If it's a frontage, it says 5 feet. It doesn't say.
That's what I'm saying. That's my point. That's something, a good example potentially of what should be amended.
Yeah. So in the meantime, how do you treat that?
I think if you acknowledge that it needs to be amended, it needs to be fixed, you can legally suspend the enforcement of anything as a ruling body. So if you choose to do that, whether it's individually by a variance, which is kind of the same thing, or just as a matter of across-the-board enforcement, suspend the friggin' rule. Suspend the law, because you have the authority as a rulemaking body to do that. Be very clear, and then until it's actually amended and implemented.
So then we're picking and choosing which ordinances we're going to enforce and not.
As long as you're picking and choosing the ordinance and not the person who
No,
it's
I'm not
enforced
picking the
against.
person.
Which I'm
I
not
don't
alleging you
care.
are, but that's kind of the feel I was getting, is that picking, yes, you can pick and choose as, again, the legislative body that has jurisdiction over this town. And I don't give a damn what anybody says, the town board is just as important as the state legislature. You know, the government that rules locally is who rules most effectively. And it affects most people directly. So, yes, you go through there and you have a discussion about, you know, this ordinance says that. We think it should apply to fences, perfectly a rational basis to uphold the life, health, safety, and welfare and morals of this community. What about bushes? Well, we don't think so. We can't see your houses well, and there's probably a 911 reason for that. So that
There is.
Your address can be seen clearly.
Mhm.
When you're having a heart attack and the ambulance can't find your house because your lilacs are too damn tall.
Mhm.
So go figure. When you're having the big widowmaker and they can't find you, well, I guess that's karma. You didn't do your frickin' bushes like you're supposed to.
So in the meantime, do we suspend all this and just ignore it and let everything
No,
go?
I'm not suggesting that at all. You gotta maintain your site triangles. Again, life safety stuff. The things that apparently aren't as consequential, that you can take a look at and have a discussion about it. But just because one resident may have a problem with it and may have some reasonable arguments against it, or whether or not it should be enforced, then have that discussion. And here's the things that we are going to agree are not, do not have a rational basis towards the end goal of health, safety, and welfare. That's not an easy conversation to have, because we can all come up with our own scenarios, our trail of tears or what ifs. So,
Joan?
I just wanted to mention that, to the best of my recollection, you probably remember this too, Vicki. When Custer County, Custer Housing was going to do the subdivision, that's when that subdivision ordinance was written. So it was, regardless of that now it's in our general ordinance, that's just the background, and that it was specifically written because that was going to be our first subdivision. I mean, Ferguson was already there. We weren't talking about Ferguson or, you know, it was just something that they said we needed to do.
Okay,
And I'm not saying it's wrong, I'm just trying to give you a little background.
okay. My thing is,
I know, it's there.
you know, it doesn't say prior to this, after that, applying to this one but not this one, because it says in general, this is what is to be done.
is it under the, and I apologize, because I should have been more prepared and taken time to read that had I had time to do it. But is it under the heading of subdivision ordinance?
No,
It used to be,
but it is not now.
but it is not now, because when we gave all of our ordinances to that company, they took it out. It's not considered the subdivision ordinance anyway, or anymore, it's just
But this has been in place for
This
quite
has
some
been.
time.
And then-
Deb,
10 years, I think.
did you have something? No.
There-
Kathy?
Chuck did.
I guess I'm just confused on what a citizen is supposed to follow.
Well, I'm confused too. Chuck?
You can't have, you know, an ordinance and you get a notice about one thing, because you feel it's a valid thing, but then the other one isn't.
Chuck?
Is there anything in the ordinance that says anything about on-street parking? I know in Rapid City they have a hell of a time with that.
I don't know. Would it be applicable anyway? Would it apply to this development but not that? That's my problem. There's
Well,
no
you have-
consistency
when you
here.
develop, You have to make allowances for parking, and it doesn't matter if it's a brand new house or an old house.
Okay, but,
You can't park your motor home out in the middle of the street on the curb. I mean, they fight that all the time in Robbinsdale, in the older part. But just, the lots were so small that if you own more than one car, one of them's gonna be parked out in the street. And it really raises hell with snow removal and everything that comes
I
down the
understand
road.
that. But, can you park a camper in the right of way and leave it for months and months and months and months? Kel?
Yeah, I mean, I just like to make the point that I do think, as far as my understanding goes, that the ordinances should be applied equally to all, you know. I mean,
That's
it's-
what I was trying to do.
Yeah, and so, and the other thing is, I think there's some ordinances in here that I do disagree with, but I don't
I do
think we
too.
should suspend, the application of them. But I think that, like he said, it would be, Kent said, it would be, a good idea to review those ones and see, like he said also, to see if we do need them and see if things, you know, I mean, I'm not ever gonna agree against safety issues or
No, I
things like that,
understand that.
general welfare, but, I mean, I don't wanna put you on the spot, Kent, but I did ask you about this one earlier.
Yeah, so let's go back before that break.
No worries.
Go ahead. Which one again?
So it's right here, so it says, basically, my question on here is, it goes along, measured 20 feet along the property line from the intersection of two streets, so what, I mean, is there a general rule of where the intersection of two streets should start, that we should start measuring from? Because, a good point that Jerry made was, you know, your property line doesn't generally go out to the street, right?
So doesn't your property line start at your property pin? And go property pin to property pin?
That's your, yes, that's your boundaries. And the right of way, there's the physical street, which never takes up all of the right of way.
No.
The driving surface never does, it's not intended to. But, so, if you're talking about the physical street, where the blacktop and perhaps a 2-foot shoulder or something, whatever that standard is where the two streets meet, I would say. Not simply right of way to right of way. because then you've got a much larger space than I think is anticipated or contemplated in the ordinance.
So are we going right of way? Are we doing property pin to property pin? I'm
Property pin would
confused.
be considered, would start where your property pin is, beyond that is right of way.
Okay.
Because that's your boundary. So, however, that may not be where the physical street is. And again, physical streets also in that 66-foot right of way or 50-foot or 80-foot right of way, that drive top might only be 40 feet. And it may not be in the center. It may be clear to one side.
How do you qualify the difference? Because in one area it's saying property line, in another it's saying right of way.
It's saying.
So it's contradicting its own ordinance, and so how do we enforce
At
it?
times it will. However, what is the intent of the ordinance? Again, when it comes to life safety issues, site triangle being the clearest example, that the intent is to not have obstructive view.
Right. So then how do you enforce frontage? That's not, in 9 times out of 10, not a life safety issue. So if that is not applicable, how do you make the ruling, oh, I'm going to apply that, or I'm not? It's written, so it should be acted upon because it is in the ordinance book.
Right. And I wanna backstep a little bit from fence versus the lilac bushes, that scenario. Because when you do consider with the law, how it would apply those standards, again, the rational basis is a very low threshold. There has to be a simple rationale as to why you as a community, rule makers and citizens, why they have voted for it in the first place, whatever. What is considered a rational basis based on your community standards and the life safety issues of the, that are needed. Well, 911, which came into since the late 80s, and frankly, I helped introduce the 911 system in Rapid City in the early 90s. That's when we started giving street numbers to people way the hell off there for the 911 grid.
Right.
Okay, so it would only stand to reason, and it does, that there be a visible address to 911 responders. And if your bushes need to be 5 feet or less in order to implement that, that's your rational basis. That's an enforceable law. So if it's an enforceable law, then enforce it. I guess, so I seem like I'm backtracking here a little bit because I am. Unless there's a post and we're gonna require everybody to have a post out in front of their house that says, 1012 such and such street. You do have to have, and it is required, that there be legible numbers, preferably reflective, I believe, on your house.
So if those are not in place, then there can be a complaint filed to get them rectified.
If the ordinance requires that. Again, we're just trying to, it's our job to presuppose a lot of different things that may never hopefully happen.
I know,
But when they do, oh shit.
yeah.
So, if you're having the big one and they can't find your house, I go back to that example.
Mhm.
We gotta get our point made real clear real quick. And gee, where were you, Tom, when you let me have my bushes too high?
Exactly,
So there's your catch-22.
exactly. Mark?
Sorry. I still feel in this whole conversation that there's two things getting smashed into one. Yes, okay, you're talking about fences and bushes within your property line, and we're talking about sight lines and sight triangles.
Two different things.
Sight triangle shouldn't have anything to do with your personal property line.
Correct.
It makes no difference. If it says that in the ordinance, it needs to be changed.
Concur.
But in
I
the
mean,
meantime, it's still
Did I
there.
hear that wrong? When they were talking about sight lines, that they're talking about property pins and 20-foot setbacks? Well, that's for a structure. That ordinance makes no sense the way it's written.
The specific aspect and specific intent of that ordinance is to have no no object or anything else obscuring your view within a certain angle. That's all it is,
Right,
regardless of where your pins are. where your-
exactly.
So that's one thing, and it is very, very different than the frontage bushes.
Yes, I understand that. Donna?
Well, we had an incident down in our development. This lady had a beautiful flower bed. Well, I went by and I go, where'd that fire hydrant go that was there? Well, she had planted beautiful red flowers around this red fire hydrant.
You could not find it.
Perfect camouflage.
Yeah.
Yeah, and she was mad. She's finally waving and speaking now, but she was mad because we made her move her flowers. Well, I had 3 people go by there and say, where is that fire hydrant? Well, we can't find it. I said, yeah, because the red flowers are camouflaging it.
Yeah.
And, I mean, that is I said to her, I said, you know, I went down and visited with her after she got her letter and everything. I said, you know, what if it's your house that's on fire? Do you want the firemen to be able to find the fire?
Absolutely, great example.
Yeah, yeah. And I mean, she finally waves, so.
Mark?
Okay, once again, I guess, just to clarify, one single bush is much different than a 6-foot fence or a 6-foot row of bushes totally surrounding your property, is it not? I mean, if it's a tree that's growing in the right of way, are we gonna expect people to cut down their trees?
Has been expected before. Monty?
If you pull up to an intersection and you look both ways and you can't see because there's a bush sticking out in your way, it's a problem. If that ain't the case, why should anybody worry about it?
Because it's in the ordinance.
Yeah, see, that's what the problem is right there, common sense.
No, it's written in the
Yeah, I
ordinance, so
know,
is it
but
common
the
sense or is it the law?
Ordinance is written for a reason, so if you pull up to an intersection, you can see around it without hitting somebody or getting hit yourself. Just
So
like-
where in the ordinance does it state that? It does not.
Okay,
It
so we
states
cut
this
down
is
all
what
our
is
trees
supposed to
around here
happen.
and get everything trimmed back, and then it's like, you got an ugly town.
We have
Take away
another,
all the trees that's putting oxygen in the air.
Not the leaves and
Jill?
bushes.
I know the tree thing, if the branches just can't be hanging down, if they have to be trimmed up so you have a site.
Yeah, and taller trees sometimes ain't
Yeah,
an
you can
issue.
still have your tree there, but the
Yeah,
branches need to be trimmed.
exactly.
8 feet.
Mark?
Okay, that's my last thing. I think every intersection should be safe.
Yeah.
Yes.
We should have clear sight lines.
Absolutely.
Everybody should follow through with it. But I think the board should sit down and look at, even if an ordinance needs to be written that's specifically set out for that, that establishes the clear measurements from
Right.
what point of, I mean, the DOT even has regulations
Sure,
for this. Fog line, back, crest of the road height, make it so clear that nobody can say, hey, you know, I'm here, this was here.
That's where we're trying
That's
to
what we're
get.
trying to point out.
Yeah, we're trying to get to that point.
But I
And
think
it's
until the
clear
ordinance
as mud.
is changed, I don't think you can be clear. I don't think any citizen knows.
No, so how do you enforce it?
I don't
What do
think
you
can.
do?
I-
So
I'm not an
what, we
attorney,
we
but-
pick out this one and suspend it, and we pick out this one and suspend it, but we act on this one.
Because it blocks your view. It's danger, it's a dangerous situation, you gotta take care of that.
Linda?
I think at this point, this list was what is the problem, has been the problem for whatever it is, a couple weeks, a month, whatever it is. And I think we should tonight address each one separately and take care of it however we're taking care of it. And then as far as any other abatements, do I think we should not do any? No. I mean, we have to continue to do our health, safety, and welfare issues. We have to. And that does include the grass issues. And I'll tell the reason it includes grass is because of the snakes
And mosquitoes.
and mosquitoes.
And we're gonna have plenty of them.
And we probably will. We've already had a few snakes. So, but as far as the ordinances, I think it's very clear we need to go through them with a fine tooth comb.
Obviously.
And I don't think that it's already 7:30 tonight. I don't think that tonight is the night that we're actually gonna be able to do that because there's other things on the list. But I think that that is, I don't know if we need just an ordinance committee to do this, or if we wanna do it in the full board with work sessions, but I think that it needs to be done. But as for tonight, I think the issues that brought most of the people in tonight are the issues because of this list. And I think that we need to address each one personally tonight and get that done with. That being said, I also believe that maybe the standards of how it is done need to be changed tonight. In the past, it was always done, a person would come in and complain. I think this is when you were our attorney back then. And when there was a complaint, anybody could complain. But they had to come up here to the office and they had to sign a complaint form. At that time, the office staff locked away the complaint form so that nobody else could see who signed that complaint form. The office staff confirmed that they had gotten it, and they had gotten it from a citizen, from a Hermosa citizen. That's all they needed to do. Then 2 board members went out and verified the complaint. Okay? I understand why you did not measure mine because you were afraid to get on my property line.
I'm not getting on anybody's property line.
Anybody's property line, okay.
Anybody.
But the fact of the matter is, in the right of way, the town member could be there. They could measure within the right of way and on the stop signs, and they should have verified whoever I don't care who to. I don't care if it's 2 people from Rapid City. But anyway, the verification should have been made that, like in my case, and I'll pick on myself because I can. I'm on the corner, but it was not dangerous. I am within my feet. I measured it. I know that my corner is safe on that stop sign. And then I wouldn't have even gotten a letter. The person that complained and the 2 people that verified it, could have come into the office and said, okay, this complaint is not valid, we measured it, it's okay. And then the person that actually can unlock the drawer and find out, get that complaint form, can call the person that made the complaint and say, that has been verified and it is not a problem. Or
Okay.
that has been verified and it is a problem and we will address it.
Okay, in defense of that, all that had to be done was someone call me back and say, I went out, I verified it, please take me off the list.
Right, and however, in that scenario, yes, any resident, which you all are, any resident can file a complaint to the city about a non-conforming issue, right? And yes, at that point, the city, the town becomes the complainant, not that person.
Correct.
That preserves the anonymity.
Right.
Again, locking that complaint away, nobody needs to know. All it needs to do is verify. Whether it's you or Vicky or anybody else, that brings that complaint to the awareness of the town.
Correct.
At that point, maybe that's where the process broke down a little bit here. I don't know for sure, but let's say you and another go out that property, always have problems. Okay, did anybody, a third party, another council person, staff member, whatever, go out and verify that in fact exists?
So how many verifications do we need?
Well, in that event, you would be essentially the complainant. You're the one bringing it to the knowledge of the town, right? And not that that's untrustworthy or anything like that, but as a CYA, to have that verified by another member or whatever.
Somebody else.
That's why we do two. That's why
Two
I
somebody's.
take complaints. 9 times out of 10, they call me because I don't give out the name,
Right.
ever. So I write the complaint, I leave it anonymous. I go and Donna and I have been on the committee. We've gone and verified. When I wrote some of them, I said, please verify. All that had to be done was call back and said, I have checked my measurements. I am in compliance, done. Jerry, did you have something?
Yeah, and we're talking, and this goes back to a little bit about another thing that happened in the community. And you're talking about the rationale and whether, you know, what's the reason and stuff like that. There's a person who actually was 8 inches over an easement. And that person wasn't given no special treatment. That person had to get a lawyer. There's a potential lawsuit going to be still filed against the town. The person has already done everything they have to do within the time frames, so that can be done. When you're looking at rationale, and one other thing I'm going to talk about, and you talk about health and safety. Just south of here, we have a community, and there's always comments that are made. Well, we got to have ordinances or we'll look like Fairburn. Well, they had a fire at Fairburn on a piece of property, and the firemen could not get around on that property. It was fenced in. Their hoses were getting caught on everything. And the way I understand it, the next day, they found a child in the corner of the property dead. So when you look at different things, and then when we talk about fire stuff, you know, 2 board members told me that even though, in a meeting, recorded, even though we approved the plat, doesn't mean we're gonna approve to build a house on that. They said, we'll have to get law enforcement involved, we'll have to get fire involved. Now I'm gonna talk about, you know, Linda's spot. I think it'd be a good place to go on and look at. And she's the one who's saying that firemen couldn't get to my place. I was gonna have it set up so they can drive right through my property. There's no way a fire person can get on her property and fight it safely.
I don't know, 'cause I don't know the facts.
My question would be, if Donna and I choose to continue to do this, what do we act on and what do we not?
I mean, is it
I
worth
mean,
our
shall
time
we
to go
just
out
go
and do
with the
this?
grass ordinance and nuisance, or I don't know where to go with it now. I don't know what to follow.
How many of these are iffy, if you will?
Depends on who you are and what you read.
Right, so is the grass over 5 or 6 inches, whatever the ordinance says?
Usually it's 8.
It's a yes or no. Then, and 8 inches is the cutoff, no pun intended. To me, it sounds a little high, but anyhow, irrelevant. Whatever it says, it either is or isn't.
That's what I'm after here. Either it is or it isn't.
Okay, so enforce it. Site triangle. Is there something that's obscuring vision within a clearly defined parameter, physical parameter, angles? Either is or isn't. So enforce it. Now, they can choose not to comply, and the city can go in and abate it and assess that cost of the abatement to that property under the law.
I know.
And then they can fight it at that level if they choose. Otherwise, that abatement stays on their deed, their title. And when they go to sell it, at that time, they either pay it, it gets paid, or they sue over it.
Donna?
Well, as I can see, we're not getting any far in this lilac bushes, so I think what we need to do is pull that ordinance. The ones that are on the list right now, I think they should let their conscience be their guide. Do they want to do something about them, or do they not want to do something about them? We need to re-look at that ordinance and go from there. We've spent way too much time on this one little
But are they
bush.
willing to accept the
But
liability if
here's
there's
the
an
thing, is
accident?
that the crux? And I respectfully disagree with the conscience be your guide thing, because our consciences, we all rationalize our own self-interest. And we
Exactly.
all do it, okay? Nobody's bad, nobody's whatever. But if you can go down the list here and say, okay, that's the grass, okay, that has to be done. That has junk on it, has to be cleaned up. And there might be 5 of the, 22, whatever there are, that are like, okay, that deserves more time and review, and that's something we're not 100% sure is all that serves the good of the, whatever the public. So if we should be able to shoot that through that in 5 minutes, so long as we don't sit there and debate every single lilac bush.
Yeah.
Okay, let's just get that done. And, okay, underage child on 4-wheeler with no helmet, I don't understand why that's an ordinance violation. It may be illegal.
On the city street.
Okay, but I don't know who it is, I don't even know who reported it, don't care, it doesn't matter. But that's a thing that happened, and that's one of those things that, okay, you call them up and say, little Eddie didn't have his helmet on, so get
But
it.
he's old enough.
But he's
enough to
underage and he's riding on the city street, and
Then that's.
all I
that's
did was had a letter sent regarding the
a
ordinance
friendly reminder.
to them.
A
That's
friendly
all I
reminder.
did.
And, but if it continues, then you'll have the sheriff's office issue a citation.
Right.
And as, I think even as a third-class municipality, I think even the mayors can issue citations. They have law enforcement
Well, I
ability.
think it's a safety issue more than anything.
Sure it
It
is.
was basically the complaint, send a letter,
So the
draw it
letter-
to the attention of the
So that
homeowner,
went
the
out.
parent. It went out. As
Why
far
is
as
it an
I'm
issue now on
concerned,
this
unless
list?
it's,
I don't get it.
huh?
Why is it an issue on this list?
It just fell on the list because it was a complaint form and it was put on the spreadsheet
But
to
somebody-
say,
but-
so it needs to be checked off.
So-
And I haven't been back to the spreadsheet to check anything off.
So Ariana Halakha disagreed with,
Pardon me?
the person you sent it to, Ariana, did she disagree?
I haven't heard a word.
Okay, so I don't understand, it's just, you're just saying it's on the list because,
It just
That's
was
just
to
one of the
draw the
things that were on.
attention to say they have been given the information
okay,
so that this does not happen again.
okay. All right. Got it. So, that's what I'm talking about though. Some of these can be addressed that easily. Some of them,
Well, I can go back through and cross a bunch of them off, but I haven't had the ability to do
sure,
that,
no, I got that.
because it's been held up and I could have eliminated a bunch of it. Jerry?
Just one question. This was a work session. It wasn't identified as a meeting, and the decisions were gonna be made. You can't make decisions in a work session.
Nope.
It's not fair to the other citizens that are on that list and that they're not being here. That's not fair. And it's, what about the 6 or 7 citizens who read the ordinance and said, okay, that's what the ordinance says. Now, do I agree with the ordinance? No, I think what Mark was saying would probably be a better ordinance than the pen, because it makes sense. But at this point in time, that's what the ordinance says. So how about the 6 or 7 of us that said, okay, this is an ordinance, we live in the community, that's what it is, we did it. And then other people aren't?
Well, and if you will recall, I publicly thanked the members that have conformed
Oh, you did?
and done what they
Yeah,
are
you
supposed to do,
talked
and
to
I
every
even
single
stopped by
citizen.
your house and said thank you very much.
To every single citizen that did comply.
Oh, I'm sorry, Kel.
I was just curious, so on the agenda that said we're gonna have a discussion about this and, you know.
And we've had the discussion.
Obviously, we've had a pretty good one, you know, but, so what, past that discussion, what is our goal for this section of the meeting?
That's what I'm trying to achieve.
Okay?
And Kent just went through and said, I don't know, as far as I'm concerned, we'll do the nuisance as far as grass and that kind of thing. Junk in the yards, that type of thing. Beyond that, I guess we'll have to bring any other complaint that would be subject to this subdivision, the age, blah, blah, blah. We'll have to bring them back to the board, put them on the board agenda for the board to decide, I guess. It's the only other thing I can come up with.
And at the official act that we did take regarding this was suspending the enforcement action until this session.
Great.
Now, so we essentially pre-authorized, but I agree with you, Jerry, this was not advertised as a meeting where official action can be taken.
No.
However, it is identified as a meeting and from an official act that said what is discussed here and thought through here will then affect whether or not that suspension applies to whichever case. Okay, so it's kind of a pre-authorized deal. Sounds kind of loosey-goosey, but I really don't think it is. But I don't disagree with you that unless it's properly advertised and so forth, no official action shall be taken. However, you already been pre-authorized to make that freaking decision and get it done and move forward here. Because you don't want to wait another 2 weeks. So now, you know,
That's what I'm
the grass is
trying
14
to
inches
get.
tall. So I would say that anything with grass and site triangle, go ahead and proceed with the enforcement action. Anything that's kind of iffy, based on our discussions here tonight, that we were like thinking that, yeah, that one's pretty clear cut, or that one's kind of a head scratcher, we're not sure that's in the best interest of the community to go forward, then set that one aside and don't do it. But it doesn't have to be all or none. Some can be decided to, tomorrow morning, it's the instruction to staff or whomever to go ahead and proceed with the next step of the enforcement action. I think that's very logical. I think we can do that very quickly here. If you want to do it right now, or maybe we've already done it based on our conversation.
For the most part, it's pretty well done.
Okay.
Let's move on then.
Yeah.
Okay. Vendor permit fees. Hi, Nick.
Hi,
How you doing today?
good, how are you guys?
It's kind of a loaded question. With a loaded answer and you don't want it. So, what are we are looking at the various forms and applications of the fees pertaining to vendors, and I'm assuming Jill has updates.
Well, I don't have a lot of updates on the vendor permit. That's in the packet here.
Right.
I think we need to get together and redo our vendor permit. There's, you can have a permit for a peddler who travels through town, or you come in as a vendor and set up something in town. Or I also think we need to look at possibly getting a special event permit,
good.
which would apply to, I think, what Nick wants to do. I did copy the special event sample from, I believe this is from the town of Mitchell, which is a huge town and has a lot of information on it. But I think we could pick and choose out of that special event sample that I have, what might work for our town. So as we go forward with the vendor fairs and different things in town, we can just have a specific permit for that. I noticed a lot of towns, I think I put a little spreadsheet in there of what other towns are doing.
I've seen it too, but.
Yeah, they're kind of all over the board for pricing, and it seems to me like a lot of towns will have a peddler vendor permit and then a separate one for food trucks, and then also a separate one for special events.
Can I ask a stupid question? Why are the permits so different for food trucks than,
Health, safety.
Health, yeah,
Okay.
health, safety,
Okay.
we
Have a
wanna make sure that
certificate.
they're following, they usually have propane in there, they're cooking, they wanna follow.
But
make
they
sure-
also have to have.
Serve safe
a
and all
serve
that.
safe certificate
Okay.
in order to have.
Yeah, and ours isn't really built to ask for that, ours is just real generic. I don't think we
yeah, I think we need to have a
Sat down
serve safe
and-
section.
looked at it. I mean, I spent a lot of time just digging at everybody else's stuff and they're just all so different. I'd like some more time to try to put something together. Here's the spreadsheet with the different towns on it and their prices. I think they're kind of all over the board. I think maybe at the next board meeting, if we could possibly just come up with an agreement for now for what we want to do for Nick, so he can move forward this summer and do what he wants to do. And then we can tweak all of our permits, so maybe next year we're just ready for everything.
I think that's a really good idea.
Okay, Nick, do you have any questions or?
I had a couple, like, what was your kind of idea for the August one, and what can we kind of expect?
I'm just the water bill girl. I don't know. I don't know what,
So what are you doing for, is it in, with the fair, is that what it's
Yeah,
with?
conduct, yep.
And what are you planning on doing as far as for your permit? What are you gonna offer?
We're doing the same thing as we are for the June 22nd one.
And then you'll have alcohol and everything, is that what you're doing?
Yeah,
And
but we
then
already have a
separate,
license for that.
you'll
yeah.
just have vendors come in just like you are for the
Yep.
Hermosa Connects one?
Correct.
And then you're gonna rent booths, rent tables or whatever to them?
Yep.
Okay.
so we've already approved everything you're doing in June, right?
Yep.
So can we ditto on what he wants to do in August? Same rules?
I would think.
Do we need to have
That's
that
where
on the?
I would go,
Do we
but
need to have that on the agenda for the
Yes,
next board
we do.
meeting, so he gets an
Yes.
answer?
yes.
Okay, and then I will work on getting, I don't know if we're gonna have time to go through all the permits. So ditto for what we're gonna do, and we'll get it on the board meeting, which is the
June 4th.
June 4th. And we'll make a decision then, make a motion on it, and you'll be good for August. How does that sound?
Sure, sounds good to me.
Okay, all right, if you have any other questions, give me a call, let me know so we can jot them down and discuss it at the board meeting.
Sounds good.
Okay.
And the other question I had, this list of towns, when I was looking at them, they're all bigger than us except for, what was it?
Yeah, I know, I couldn't really.
For all the small towns I was looking up, all of them were pretty, they didn't really have vendor fee.
Yeah, because the
necessarily.
prices are all over the board. I mean, I get where the tourist towns are probably charging a lot for a vendor to set up, and I don't think we really need to do that.
No.
And we're trying to get people to come to our
Right,
town.
I was gonna say, a lot of towns would stand glad to have you there.
Yeah,
Which is kind of
I
us.
mean, all the people that come to the fair, they're gonna stop at the gas station, they're gonna go to the dollar
Right.
store, they're gonna eat at the Lazy R, possibly.
Right.
So we wanna bring that business here,
Good.
so.
Yes, Nick,
For,
thank you.
I'd say for our events, we get charged sales tax for the booth charge, so you guys reading that, and then also whatever the vendors sell, and that's all regulated by the state, so you guys don't even have to really do anything for that, you know.
No.
Right.
Correct. Yes, ma'am.
And I was just gonna say along that, I know that we do have a copy of Buffalo, South Dakota's, what is it, vendor?
Vendor permit rules or something.
Yeah,
I
vendor
don't know
permit
what they-
rules, if you guys wanted that, they are like ridiculously similar within 14 people population. So
Yeah.
super similar to this town if you guys wanted that as well.
Sure, yes.
They're not as much there to offer as we do.
Yeah. Would you guys bring that in and share it with Joe?
Sure.
That would be awesome.
Okay, yeah, that'd be great.
Okay.
What do we have on there next?
Permits.
Update permits.
Update permits, okay. I think what I'm gonna do is I've gone through, I have in a packet the old permits. I have another packet with all the new permits that I have made changes on. And they're all numbered, and every change I have made is been highlighted in pink. I think everything I don't know that we have time to sit and go through all of them, but if I could, everyone could take these home and just flip through them, maybe we can go through them real quick at the next, does this need to be on a board? Do we need
Yeah.
to make a motion at a board meeting? So I'd be happy just to sit down, I think I made it really organized. I highlighted all the changes I made, you know, I didn't really change anything on there, I tried to enhance and make everything more clear. So if you guys just want to take those home and look.
So is
through
this
them.
pink paper, does that mark in between the?
It is, I was trying to like whip through it tonight so we could be, you know, like when everyone's flipping and they can't find everything.
Good idea.
Good job.
I
Yep,
used to own a print-
excellent.
print
Good
shop, so I was
idea.
trained. What else do we have on here? Water issues, conflict of interest. I would, before we go it, I know 8 o'clock is the deadline, is bring up this billable locate issue that we just kind
Yeah,
of
I
found
think there's-
yesterday.
We need to discuss that, and we need to discuss pace with Chuck before we adjourn tonight. The others will
Okay,
have to
so I
move to
wanna
another
just-
work session.
I just want to pick your brain on this billable locate. This is going to
That's
be
fine.
a nightmare. So we found the latest, greatest locate list, or his contract, where last month we were charging over 20 locates. We were charging those to Mount Rushmore Telephone, which we did make a motion at a meeting to do that, and they knew they were going to do about it. They were absolutely not happy about it when they got the invoice. With that being said, we dug the contract out, and the correct contract, we went back and looked at the date that the email came from Jerry with the changes, and the billable locates, he does 10 per month, and then over 10, they're $100 a piece.
Okay.
So my question is, we're passing this cost on to who? The person that's getting the locate done? We do not have that on any of our fee schedules.
Good point.
We do not have that on any of our applications. We do not have it in an ordinance. It is not posted anywhere that we do that. So I'm feeling a little uneasy about that because Mount Rushmore really gave me some pushback on their bill for $475. Right now, for the month of May, it's only the 22nd, we are at 18 locates over the 10, which is $1,800. So I will be billing, I believe, Mount Rushmore Telephone, I believe $1,200, and the month is not over.
Great.
But we did make a motion for Mount Rushmore. The rest of the folks that are on the spreadsheet that I have here, I just want to know how to go forward with, I really believe this needs to be put on our fee schedule. It needs to be on a document when people come in and they know about it. There's someone on there right now, Dakota Brigade. What are they here doing?
Go to barricade,
Barricade?
they're signing outfit.
Okay, so there's 2 of them on there, so I'm gonna have to bill them $200, correct?
I think it's 45, I don't remember how many.
It's 100.
Huh?
It's 100.
It got changed.
Your contract was increased, Chuck, to 100 once you decided that you were gonna buy the locate machine, the actually meter to do the locating. And that's when that was changed and it was approved by the board and your contract and signed.
My question is, do we need to possibly revisit that? I mean, 100,
I think we do.
I mean, he's making more money than Kent is right now.
Excuse me.
Nobody makes more money than Kent does.
$100, how many locates do you do an hour?
Dream big, Kent.
Okay, the other thing I did was I talked to Trinity Rapp from Mount Rushmore Telephone. She made me call this Cody Gregg, who is the director of the 811 locates for the state of South Dakota. She told me to call her and tell me what we were doing. And this woman had never heard of anyone in the entire state ever doing anything like we're doing right here. Turning around and billing for locates. So I didn't know what to tell her except that it's the town of Hermosa. I don't know what to tell you. She said, I've never heard any.
How do they do that in other towns, don't they? Who gets paid to do them?
I don't, well, South Dakota locates are, well, we're paying Chuck to go locate
Well,
the,
Jim's locating, I've had them down here several times, and it's about $100 to have them come locate.
Right, I remember that. Jerry?
Yeah, a lot of communities, they have people within their own public works department that go out and do the locates. The electric company used to do their own locates, but they figured that their people's time was better spent doing electrical fixing, and therefore they contracted that out. You know, there's two different things here. What Chuck gets paid, the reason we did that, Chuck deserves to get paid because he's doing that above and beyond. A year ago, he got stuck with 100 or 200 a month and never got a penny for it. So there's two different things here. You know, what we're gonna do, are we gonna bill somebody else, then how do you figure that out? You know, if you're gonna have a locate that month, you wanna be the first one in, so you get part of the 10. But it's two different things. What Chuck gets paid is in his contract, and that's what he deserves. Now, where the town is gonna try to go back and get the reimbursement from places, that's gonna have to be on a whole different thing.
we need to hash that out because I just feel,
Okay, we'll put it on the agenda.
I mean, because right now we're at
He's paid.
18 over the 20 and the month isn't over, that's $1,800 that he's gonna bill the town of Hermosa.
So are you saying that he doesn't deserve?
No, I'm not
No,
saying
that's
anything
not
like
what she's saying.
that. No,
No.
no, I'm not saying
No.
that. I just want to,
I
I want it
just
to
want to
be,
clarify that.
no, I want it to be out, because now when I turn around and bill these people, they're gonna say, hey, we didn't know about that. It's not on our fee schedule.
Right.
It's not on a document anywhere. We don't have it posted anywhere. It just seems very underhanded and we didn't think this through.
Needs to be clear and out in the
Yeah.
open.
Yes, that's all I want, because you know who
Linda.
they're gonna call first? They're gonna call me.
Right, Linda.
Well, first off,
Broad shoulders.
if the telephone company is doing this work, the telephone company should have come to the town of Hermosa and said, we need to do this. Did they?
And the telephone company, we made a motion that night that they would pay $45 because
No,
that's.
we made the motion. Were they here at that meeting? Did they have a say in it?
I don't know if they were here, but I called Trinity the next day and told her that.
Okay, but
I don't think they were at the meetings.
They were not.
my point is that they should have come to the town and said, okay, we've got this and this and this to do, and it's gonna take us approximately 2 or 3 months, and it's gonna take a locate, you know, we're gonna need every house located or whatever, and do we have permission to do this? And if the town just said, yeah, you have permission to do that, with no,
It was part of, the motion was part of approving their digging and grading permit.
so I guess I would like to see that and read that and see exactly what that says. Because if we authorize them to go ahead and do all this work without charging them at the time, we didn't think about it, then isn't that our fault? I mean,
Yeah, it would be.
that's our fault. And that is something that, being a small town, you know, we're not used to that
Are
kind
you
of
looking
thing.
for that, Terry? I have
You
it.
you see what I
So
mean?
what so what are you saying, Linda, that Chuck shouldn't get paid for these locates?
No, I'm saying nothing about Chuck. Chuck has a job to do, and if the
Just that the
locates
town-
need to be done, they need to be done. But my point here is that in the future, should something like this happen, the phone company, the cable companies, I don't care, light company, whoever, comes to us to say we need to do this or we want to do this in your town, we need to think more seriously about it to think it through better as to what is it gonna cost us as a town? What is it gonna do to the town?
We're talking about, I'm sorry, maybe out of order here, but we're talking about the fiber optic sewer water locates, right?
No.
What are we talking, kind of locates?
Actually, my locate list is water and sewer. Anything else is located by, and of course, the problem we have with gas is they will not locate. But they sure as hell know how to charge you when you cut.
Right.
So.
What's the public, isn't it 811 or 5, was there there's one of those 1-1 numbers that call for
811.
locates.
Yeah,
They call you at 2 o'clock in the
call before you
morning.
dig, 811.
Right. And isn't that paid for by the state? Right? So if,
No.
who's,
Actually, when you call, I get my contact out of Texas.
okay,
And they are there
Mark,
24
you can
hours
put
a
your
day.
hand
right,
down.
and
Mark.
they're the one that's,
Put your hand
that's,
down. Alcohol.
I just
provides
thought-
the assurance or perhaps insurance that if you hit something and they didn't find it, then it's on them. Now, there's several private outfits that do the locates also that are compensated by whoever is doing the digging, meaning who's ever paying the excavating entity to do it. That's the private aspect of it. Otherwise, wouldn't 811 be taking care of all of this? And if they charge somebody, then they charge Midco, or they charge, I don't understand what it is that we're doing that the town would be responsible to pay anybody. But when Chuck is doing work and needs to excavate, yes, of course you want to do locates to cover yourself. Or whomever is doing it on behalf of the town, then that event, the town, yeah, would pay, because now they are the quote-unquote authorizing party or the developer, if you will.
Okay. Mark,
We have,
Mark,
I have an abundance of experience with 811 and locates. All they are is like a service. You call them, they send out work orders to the telephone, electric, plumbing. Those individual owners either have somebody on their own staff or they subcontract a larger company that comes in and does it. But the utility owner, whether they bill somebody else or not, are always responsible for the fees.
Okay.
So, I mean, electric pays electric, water and sewer pays water and sewer. Now, you can bill whatever customer you're doing it for to recoup that, which most people do. But, yeah, I mean, it's not free. Somebody's always paying down the line. The utility owner foots the bill and then passes it on.
Which in this case, the utility owner on the water and sewer would be us, or whoever is, if there's a private developer, construction coming in, they've got to get locates, you know.
Chuck, did you have something more?
well, I was just gonna say, we've had 2 instances that locates were made and they hit the mains anyway. In both cases, the contractor fixed it, at their expense. However, I mean, it's always that last inch that gets in trouble. And we're jetting and hammering everything here in town and looking at the repairs that have been made in the past and, if there's any infiltration and things like that. But through personal experience, the one call is very cheap compared to, I didn't know it was there. And I hit,
Right.
had one instance that was the telephone company. It was marked very clearly, so a guy pulls in and parks his pickup over the markings. The guy running the machine, I mean, they ripped an 8-inch sewer main right out of the ground. And he said, I saw the marks. But when they parked the pickup over the marks, I wasn't thinking, I knew it was there. Well, late at night, and it's the main gunner for the whole town.
Of course.
And, so then going into dark evenings and one time there, I cut a main line in Fairburn. And I called 811 and they're not on the list for locating. And Jerry made a very good point about no ordinances and one thing and another that Fairburn is a classic.
Sure.
Yeah, and, I mean, it's imperative that you locate this stuff. There is a variance. You've got to be within 18 inches of any power equipment. In other words, when you get within a certain 18 inches, it's handwork. And usually what happens, they get tired of digging by hand, so bring the excavator in and, they're here,
Right.
and I get it all the time. But that last inch is what gets you in trouble.
Of course.
So this is exactly what happened on this man's property. I mean, and they're billing for the repair. I said, you break, you fix. Pretty simple. It was located, and to verify the depth, he called me, he said, we're down 7 feet, and we don't see it. We can't find it. And I said, well, the sewer line's in a straight line from that manhole to this manhole. And it's marked, and if you're 7 feet, looking at the elevation in the two manhole, you gotta be right on top of it. Next swoop with the backhoe, they ripped her right out of the ground.
Oh, geez.
4 o'clock in the afternoon.
On Christmas Eve.
No.
Oh, that
It
has
has
happened.
happened. Yeah. So.
Deb, did you have something?
I was just wondering, so, okay, let me understand something. Chuck's in a contract, he's a subcontractor for the town. The town pays him for 10 locates at $100 a locate.
No.
No, that's part of his
No, no, no,
contract.
no,
Okay,
no.
so that's,
It's kind of-
okay, so anything over that, should he be billing Mount Rushmore and not the town? Since it's fiber optic, it's not sewer, it's not water. He's a subcontractor.
Well, I'll say whoever's receiving the service, which if it's a service, that locate service was to protect their line.
Right.
That would make sense that
Not the town to pay it, but the subcontractor to pay.
the owner, I mean, in this case, Midco, or,
Yeah.
to me would make a lot of sense. But if it's not their job, if it's not their construction job, if it's somebody else wanting to, but it's a developer wanting to bring a main from the center of the street onto their lot, but they gotta go through the myriad of different lines, fiber optics, all that stuff, then it's that developer's financial responsibility to make sure that crap isn't hit, because it sure as hell's gonna be his responsibility when it is hit.
99% of the time, the cost of repair is way outweighs what it costs to locate.
Way.
Okay. Jill?
I really don't have anything, I wanna streamline this so we're covering our butt. and
I
it's-
appreciate all you've done, because I can tell you have done extensive work. Thank you very much. Chuck?
One of the things that comes into play here when you bring Mid-Continent or Mount Rushmore or somebody in, and this has been kind of a forced situation because Mid-Continent came in and put high-speed internet all over town. Well, they had to have everything located. I mean, they tore this town completely apart. They dug on every street corner, every alley, it was just unbelievable. And left messes, no compaction, no nothing. They just filled it in, drove away, and so then when Mount Rushmore says, well, we're gonna lose all these customers, so they come up with a big deal that they're gonna put, Rushmore's gonna put fiber optic into everybody, so they're duplicating the same thing that was done. So we've got dozens and dozens and dozens of locates. And where that thing come into play is it's, you get 2 or 3 locates and it takes a good part of a half a day to do them. So consequently, that's where this thing come into play that, once these guys are out of town, this thing's gonna drop back down to maybe 10 locates in a month.
That's why it needs to be in the form of an ordinance.
Well,
Like when Midco comes in and does substandard work, all they care is about dropping it there, 1.5 feet in the ground, they're out of here. That's not acceptable, and there has to be, I would say, number one, ordinances that you replace it in a workmanlike manner as it was before, as close as possible. And that gives you your legal basis to send them an invoice saying you didn't do, and they're not gonna wanna screw with any town's ordinances if they violate them.
Mhm.
So we gotta have them in place first if they're not already. The digging ordinance, what it takes, requirements for
I mean,
the locates, the replacement of, putting it back, backfill, all that's done. It wouldn't be that tough to do, but it is essential to have that done.
pretty rough hill to follow first go, like she's saying. But once those issues are out of the way, it'll drop back to who knows. It's like Dakota Barricade. They wanted to put up 2 signs, set them on the road for the construction that's going between here and Richard. I said, well, how deep are you going? Well, no, we're not going deep, but this is what happened. There's a contact list that 811 has. They contact power company, telephone company, gas company don't locate for propane, and myself. So we're covering water, sewer, power, and just made a statement that REA does not do their own locating anymore. They hired out. ICC is a contracting firm that does this, and they're all over. And my calls come out of Texas, and they're 24 hours, so I get phone calls at 2 o'clock in the morning, or Sundays, or anything. They're there 24/7. And I say, do you know what time it is? Or they'll say, well, I got an emergency locate. I said, what are they doing? Well, they're burying fiber optic. I said, how can that be an emergency? Do you know what the fine is?
Well, the game starts at,
Yeah, the fine for calling in an emergency locate, if it proves not to be, is $7,000. What the fine is. So I cleared the air right away. I said, maybe you better look at that ticket again. Oh, no, I guess it is a routine.
yeah. Well, I'm running out of time actually.
I know.
So I
I
apologize.
know. We just had one other thing with Pace, just a fast update from Chuck.
We probably are gonna finish up tomorrow.
Okay,
We looked at some other, I think the agreement was for 10,000 feet, wasn't it,
yep.
on the contract? I looked at the amount that was done early this morning, and we were only like 5,300 feet or something.
Looking at the cane.
So we started looking at some other, because they're gonna scream foul if they don't get paid what we agreed to. So,
You don't like my M&Ms or
we'll
what?
put in some more footage of what's going on. So I just wanted to bring it up to date a little bit, that we still have the lift stations to clean, and it appeared as though that we were going to overrun the budget for what they had agreed to do, but that's not the case.
Okay.
However, if they only do half of what we agreed to, then they're gonna scream foul, and it costs us so much to come to billings to get through. They hit us about $1,500 mold fee.
Sure.
Pretty rough.
Yeah.
And they have been here and left, and went to the reservation and come back and billed us for mileage coming from the reservation back to do the work. I said, no, that's not gonna happen.
No.
So, anyway, same company, different guys. We're getting a really good handle on, we did not budget for 3 years. And the problem areas are really, really showing that. The roots have gotten way out of hand. We did a thing one year that 90% of our problems is roots. So we did a thing one year that they called a blitter root. They come in and they actually put a foam inside the pipe.
You said it didn't work with the name.
And it didn't work, no. And I said to him today, I said, what about this obliterate? He said, we quit doing it because it don't work. I said, you're right, it doesn't work. And we paid you a good chunk of money to do this. They claimed that if it made contact with the roots, they're dead. I didn't see anybody's trees dying or anything, lilac bushes, whatever. They are very nasty, lilacs are. You just can't hardly kill them. I mean, you dig them out with a backhoe and you spray the ground with killer and they'll still come back out of the roots. So, I mean, they're beautiful one time a year when they have their flowers. The rest of the time, they collect garbage and leaves and just nasty. Kind of like hollyhocks.
Okay,
So, that's the story on the, you know.
okay. Anything else real
We'll finish
briefly?
up tomorrow and everything looks pretty good. We've got a couple of problem areas, but most of it is very, very good shape for the age of it. It's put in 1960, 61. And there's been some repairs along the way. I will burn up the extra footage that we've agreed to. So we'll probably go across the road and it's kind of redundant to jet and camera PVC. No separations or, I mean, the pipe literally has to be damaged. So it's put in correctly to start with and inspected and one thing or another. It should be there for 50 years with no problem. However, you know, there are some issues along the way that the work is installed properly and, you know, blah, blah, blah.
Okay.
That's the end of that. The other part was on the gravel. We brought in, what was it, Terry?
83 point,
60 ton,
I thought it was 83.
60 ton. It's figuring out about $20 a ton.
$22. It was
Which
83
is a good price.
ton at $22.
But Fairgrounds Place, we could spend $10,000 on that road and it still wouldn't be up to. So we're basically filling the bad areas and trying to.
Fixing what we
Everybody just
can.
tickled to death to see me and the new gravel and all that, because it's been a mess. And the truck traffic that was coming out of the lagoon certainly did not help it.
Okay.
So,
Anybody have anything else briefly so we can adjourn at?
no,
Jerry?
I just want to say, there was a total difference between Rushmore Telephone, they come in, you know, they've been on corners of all my property, and when they leave, they have it all compacted, they have it all cleaned up, so.
Good.
The local company, I'm just giving a cheer out for them instead of going with some great big company that just flies in and does stuff.
Good, thank you.
These guys are really doing a good job.
Thank you, that's nice to hear. Could I have a motion, please?
To adjourn?
Yes.
I'll make the motion to adjourn. Whatever time it is.
17.
Do we have a second?
I'll second it.
I third.
All those in favor?
Aye.
Aye.
All those opposed? Motion carried. Thank you, everybody, for a nice meeting.
Chris.
Good evening.
Thank you, Ken.
Thanks, Ken.
Yes.
I have a word with you on what.
I'm available to truck.
Yeah, I need a ride home.
Oh, I know.
All right, okay, bye.
Oh, my.
They lost 10-8, good game.
Oh, fudge.
They played good though, he said. So
That's good.
That is good.
yeah. They went Sturgis tonight.
I saw your deal.
Anyway. God. So I hope I have a.
Well, if he didn't, I'll give you
I
a
will give you
ride.
a ride.
Hey Vicki, just real
No, he
quick.
hasn't even gotten tickets yet, so I have plenty of time to get there.
These are all the new.
So just real quick, I think that it's a good
That
thing
sucks.
Yes, that's
I've had it done.
send things out based on the
Well, then
ordinances, and even based on how you read them or how you understand them, because then
You did both
that
of
will
them
bring it
there?
to the forefront
Yeah, you're
if there
crazy.
is an issue with them.
Yeah, you think?
And then we can address
Yeah,
any of
no
the
doubt
issues.
about it.
I just wanted
That's,
to give you my
That's an
take on
awful
that,
lot.
you know, because
Yeah,
the
it
thing
was.
is, we all know that there are issues with the ordinances, and barring going through them one by one, you know, I mean,
Comes
we,
to surface.
yeah, we can at
Don't
least
forget
address
your purse,
some of them.
Linda.
Oh, okay.
Thank you, honey.
I don't know.
Well, I almost tripped over it and I looked down once and I thought it was mine.
Glad you didn't trip over it. Thank you.
Maybe she didn't tonight because she's
No, I had them ready, they were sitting there last night.
Just a joke.
Linda, you got your meter readings, don't you?
Yeah, I got all that.
We get packed up for you, locked
I
in here.
actually get to do it tomorrow now.
Whoops, I'm sorry.
That's
I
okay.
didn't even think about that.
I got it. I can see in the dark anyway. Thanks.
Thank you, Terry, for all you do. Bill, thank you, and thank you so very much.